take it out there?
Angel's over here. I'll take it out when it's done.
134.
134.
Looking for 134.
133. I just have to.
There it is. You got your items.
We are on the record. And the jury's coming in. What's,
Want to raise our, they're going to acquittal as a matter of law again.
I asked if there was anything we needed to take up, and I got a jury in the hallway. Just a moment. All right, so Mr. Massey has indicated that he would like to raise what exactly, sir?
Your Honor, please, we would raise our motion to judgment of acquittal as to each count. That because of the state's proof, we're no longer taking in the light most favorable to the state, and ask the court to dismiss first degree murder on each of the 3 counts, counts 1, 2, and 3. And
How is this different from what we did on yesterday? I have here motion for judgment of acquittal approximately 4:38 on yesterday. So we're going to do both? Okay, so you're asking me to dismiss the first degree. You didn't raise these issues yesterday, so let me start over. Dismiss first degree murder, count 1 of the indictment.
Your Honor, we are asking that first degree murder be dismissed.
Yes, sir. What else?
And it's taking the proof in the light equal to both parties, it would be second degree there. Same thing with count 2.
You're asking the court to dismiss count 2 of the indictment
Count 1, yes.
Count
first
1
degree murder.
and count 2 first degree murder.
Same thing with count 3.
You're asking the court to dismiss count 3 of the indictment, which is the murder and perpetration of a felony.
And it should be, well, first degree be dismissed and second degree be sent back to the jury.
Would the state like an opportunity to respond?
Yes, Your Honor. The question is whether a rational jury could find the defendant guilty of the indicted offenses as charged. If my understanding correctly, Mr. Massey is asking for not murder 1 but murder 2.
Mm-hmm.
Your Honor, the state would rely on its previous arguments from yesterday, but specifically addressing Mr. Massey's concern as far as the state has met its burden at this point in time that a rational jury could find the state has proven the case beyond a reasonable doubt. The state would rely on yesterday's statements, because nothing has really changed. The testimony of Dr. Nuschitz from yesterday. With regard to Mr. Massey's point of reducing it to a second-degree murder, the state has put within regard to count 1, which is the first-degree murder premeditated of Danielle Hoyle. The state Tennessee put on proof of that the defendant gave a confession as to shooting and killing Danielle Hoyle at Levi and Sedgwick on February 1st of 2025 here in Memphis, Shelby County, Tennessee. Your Honor, the state has put forth proof as to the element of intent and premeditation based on his search history recovered from his phone, based on his GPS phone location data from earlier in that day, driving out to the area of the crime scene and then turning around and going back out east from the direction which he came to his home. The state also put on proof of text message conversations and letters that were written between he and Artesia that shows his state of mind at the time. And so the state has put forth proof that a rational jury could reasonably find the defendant guilty beyond a reasonable doubt of first-degree murder of the unlawful killing of Danielle Hoyle. So therefore, Your Honor, the state would ask this court deny defense's motion for judgment of acquittal and sending this case to a jury based on, or reduction of count 1 to second-degree murder, and would ask the court to deny the motion at this time.
You know, I would just raise the same argument as yesterday in regard to the last two counts, which is aggravated child neglect and especially aggravated kidnapping.
With regards to the last two counts, Your Honor, aggravated child neglect and especially aggravated kidnapping and state reliance arguments from yesterday, as nothing has changed other than Dr. Newsheff's testimony, which the state submits did not negate the intentional elements. Aggravated child neglect, Your Honor, the defendant knowingly neglected Kennedy Hoyle as to adversely affect Kennedy Hoyle's health and welfare. The state of Tennessee put on proof that through the defendant's confession that he placed Kennedy Hoyle, he stated that he placed Kennedy Hoyle on the riverbank, but later admitted to throwing her by the leg into the Wolf River. Your Honor, that she also was never found. That adversely affected her health and welfare. She is deceased. Even by laying her by the river, that resulted in her dying as well. The act of neglect resulted in serious bodily injury to Kennedy Hoyle, the same points just stated by the state of Tennessee. Also, Kennedy Hoyle was 8 years of age or less. The state of Tennessee, through testimony of Ms. April Campbell, as well as the baby Kennedy, or Kennedy Hoyle's birth certificate, is established that she was less than 8 years old. She was 2 days old. Further proof was also submitted as to the defendant's GPS locations at the time, as well as that put him at Mud Island near the boat ramp, and video evidence also corroborated him as being at other locations at the time his phone says he was, to corroborate that he was with his phone as it was on Mud Island. As to the charge of especially aggravated kidnapping, the state put on proof that the defendant knowingly removed and confined Kennedy Hoyle unlawfully as to interfere substantially with her liberty. The defendant testified that he took baby Kennedy from the back of the vehicle after shooting Danielle Hoyle. He said that in his statement. And he drove with her, I think, for approximately an hour and a half before he admitted to throwing her into the Wolf River. By doing so, he substantially interfered with her liberty. He, at that time, was not a father listed on the birth certificate. He also did not have parental rights at that time as far as that would have been established. And so he did not have a legal reason to have baby Kennedy with him, but also taking into consideration the facts that he had just killed Danielle Hoyle based on his statement and the evidence presented by the state of Tennessee during the course of the trial. He unlawfully interfered with her liberty. And as a result, or during the course of, she suffered serious bodily injury during the removal confinement. She is deceased as an act that continued during the course of the especially aggravated kidnapping. For those reasons, the state would submit that a rational jury could find the defendant guilty of both of those counts beyond a reasonable doubt, and therefore ask this court to deny defense counsel's motion for judgment of acquittal at this time.
At the conclusion of the state's evidence, the defendant may move, as he has twice now, to ask for the trial judge to consider a judgment of acquittal. When confronted with a motion for judgment of acquittal, the only concern of the trial judge is the legal sufficiency of the evidence and not the weight of the evidence. Respectfully, Mr. Massey, I will have to deny your motion for judgment of acquittal. I do believe that in viewing the evidence provided in the state's case at its best light, it would be inappropriate to dismiss the first-degree murder counts in count 1, 2, and 3 of the indictment, or disturb the indictment on counts 5 and 6. Let's bring in the jury, please. courtroom. You may be seated. Ladies and gentlemen of the jury, you may have found yet another packet in your seat. These are your final jury instructions, and I shall read them to you. Members of the jury, the evidence in this case has been completed. It is my duty to instruct you on the rules of law that you must follow and apply in deciding this case. The law applicable to this case is stated in these instructions. It is your duty to consider carefully all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each instruction in light of and in harmony with all the others. You are the exclusive judges of the facts in this case. You are also the exclusive judges of the law under the direction of the court. You must apply the law to the facts in deciding this case. You should consider all of the evidence in the light of your personal observations and experiences in life. Count 1 and 2 of the indictment charges the defendant with the offense of first-degree murder, premeditated killing. The offense necessarily includes the lesser offenses of second-degree murder, reckless homicide, and criminally negligent homicide. Count 3 of the indictment charges the defendant with the offense of first-degree murder, killing and perpetration of aggravated child neglect. The offense necessarily includes the lesser offenses of second-degree murder, reckless homicide, and criminally negligent homicide. Count 4 in the indictment charges the defendant with the offense of aggravated child neglect. The offense necessarily includes the lesser offenses of child neglect. Count 5 in the indictment charges the defendant with the offense of especially aggravated kidnapping. The offense necessarily includes the lesser offenses of aggravated kidnapping, and false imprisonment. There are 5 counts in this indictment. You are to treat them as separate and distinct at all times. The indictment in this case is the formal written accusation charging the defendant with a crime. It is not evidence against the defendant and does not create any inference of guilt. The law makes it the duty of the court to give in charge to the jury all the law relative to the case on trial. The duty of the jury is to consider carefully all of the evidence delivered to you in the trial and, under the law given you by the court, to render your verdict with absolute impartiality. The jurors are the sole judges of the facts and the law as it applies to the facts in the case. In reaching your verdict, you are to consider the law in connection with the facts. The court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. You shall not have any sympathy or prejudice for or against the defendant or for or against the state of Tennessee, or allow anything but the law and the evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think truth and justice dictate. You may consider every fact and circumstance in the case in arriving at your verdict. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with those rulings. My rulings, these instructions, or any other remarks that I have made do not indicate any opinion about the facts of the case or what your verdict should be. Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements are made that you believe are not supported by the evidence, you shall disregard them. The court will now explain the law applicable to the charge in count 1 of this indictment. First-degree murder, premeditated killing. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Danielle Coyle, and that the defendant acted intentionally. A person acts intentionally when it's the person's conscious objective or desire to cause the death of Danielle Coyle, and the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Danielle Coyle, and that the defendant acted knowingly. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant killed Danielle Coyle, and that the defendant acted recklessly. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant's conduct resulted in the death of Danielle Coyle, and that the defendant acted with criminal negligence. The court will now explain the law applicable to the charge in count 2 of this indictment. First-degree murder, premeditated killing. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Kennedy Coyle, and that the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of Kennedy Coyle, and that the killing was premeditated. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Kennedy Coyle, and that the defendant acted knowingly. And that was your definition of second-degree murder. Reckless homicide. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant killed Kennedy Coyle, and that the defendant acted recklessly. Criminally negligent homicide. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant's conduct resulted in the death of Kennedy Coyle, and that the defendant acted with criminal negligence. The court will now explain the law applicable to the charge in count 3 of this indictment. First-degree murder, killing in perpetration of aggravated child neglect. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed Kennedy Coyle, and that the killing was committed in the perpetration of, or the attempt to perpetrate, the alleged aggravated child neglect. That is, that the killing was closely connected to the alleged aggravated child neglect and was not a separate, distinct, and independent event, and that the defendant intended to commit the alleged aggravated child neglect. The essential elements necessary to constitute aggravated child neglect are that the defendant knowingly neglected a child so as to adversely affect the child's health and welfare, and that the act of neglect resulted in serious bodily injury to the child, and that the child was 8 years of age or less. The elements of first-degree murder have already been set out and are previously explained in count 1 and 2 of this indictment. The intent to commit the underlying felony must exist prior to or concurrent with the commission of the act causing the death of the victim. Proof that such intent to commit the underlying felony existed before or concurrent with the act of killing is a question of fact to be decided by the jury after consideration of all the facts and circumstances. Consideration of such factors as time, place, and causation is helpful in determining whether a killing was committed in the perpetration of the alleged aggravated child neglect. The killing may precede, coincide with, or follow the aggravated child neglect and still be considered as occurring in the perpetration of the aggravated child neglect, so long as there is a connection in time, place, and continuity of action. The elements of first-degree murder, second-degree murder, voluntary manslaughter, reckless homicide, and criminally negligent homicide have already been set out and are previously explained in count 1 and 2 of this indictment. The court will now explain the law applicable to the charge in count 4 of this indictment. Aggravated child neglect. Any person who commits the offense of aggravated child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly neglected Kennedy Hoyle so as to adversely affect Kennedy Hoyle's health and welfare, and that the act of neglect resulted in serious bodily injury to Kennedy Hoyle, and that Kennedy Hoyle was 8 years of age or less. To constitute neglect, the state must prove beyond a reasonable doubt that there was an actual adverse effect to the child's health and welfare. A mere risk of harm is not sufficient. Neglect is a continuing course of conduct beginning with the first act or omission that causes adverse effects to a child's health and welfare, and can be an act of commission or omission. Child neglect. Any person who commits the offense of child neglect is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly neglected Kennedy Hoyle under 18 years of age so as to adversely affect Kennedy Hoyle's health and welfare, and that Kennedy Hoyle was 8 years of age or less. The court will now explain the law applicable to the charge in count 5 of this indictment. Especially aggravated kidnapping. Any person who commits an especially aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that Kennedy Hoyle suffered serious bodily injury during the removal or confinement. Aggravated kidnapping. Any person who commits an aggravated kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that the Kennedy Hoyle suffered serious bodily injury during the removal or confinement. Kidnapping. Any person who commits the offense of kidnapping is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knowingly removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that the removal or confinement was under circumstances that exposed Kennedy Hoyle to substantial risk of bodily injury. False imprisonment. Any person who commits the offense of false imprisonment is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant removed or confined Kennedy Hoyle unlawfully so as to interfere substantially with Kennedy Hoyle's liberty, and that the defendant acted knowingly. As to especially aggravated kidnapping, kidnapping, and false imprisonment, a removal or confinement is unlawful if it is accomplished by force, threat, or fraud, or, in the case of a person who's under the age of 13 or incompetent, if it is accomplished without the consent of a parent, guardian, or other person responsible for the general supervision of the minor's or incompetent's welfare. Although the law requires no specific period time of confinement or distance of removal, a removal or confinement interferes substantially with another's liberty if the time of confinement is significant or the distance of removal is considerable. To find the defendant guilty of this offense, you must also find beyond a reasonable doubt that the removal or confinement was to a greater degree than that necessary to commit the offenses of first-degree murder and aggravated child neglect as charged in counts 2, 3, and 4. In making this determination, you may consider all of the relevant facts and circumstances of the case, including but not limited to the following factors: the nature and duration of the alleged victim's removal or confinement by the defendant, whether the removal or confinement occurred during the commission of the separate offense, whether the interference with the alleged victim's liberty was inherent in the nature of the separate offense, whether the removal or confinement prevented the alleged victim from summoning assistance, although the defendant need not have succeeded in preventing the alleged victim from doing so, whether the removal or confinement reduced the defendant's risk of detection, although the defendant need not to have succeeded in this objective, and whether the removal or confinement created a significant danger or increased the alleged victim's risk of harm independent of that posed by the separate offense. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish the alleged first-degree murder and aggravated child neglect and was not essentially incidental to it, you must find the defendant not guilty of especially aggravated kidnapping, or false imprisonment. Definitions. Intentionally intended intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Adversely affect the child's health and welfare may include, but is not limited to, the natural effects of starvation or dehydration, adverse effects on the emotional and mental health and welfare of the child. Child means a person under 18 years of age. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Criminal negligence refers to a person who acts with criminal negligence with respect to the circumstances surrounding that the person's conduct or the result of that conduct when the person ought to be aware of a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. Identity. One of the issues in this case is the identification of the defendant as the person who committed the crime. The state has the burden of proving identity beyond a reasonable doubt. Identification testimony is an expression of belief or impression by the witness, and its value may depend on your consideration of several factors. Some of the factors that you may consider are the witness's capacity and opportunity to observe the offender. This includes, among other things, the length of time available for observation, the distance from which the witness observed, the lighting, and whether the person who committed the crime was a prior acquaintance of the witness. The degree of certainty expressed by the witness regarding the identification and the circumstances under which it was made, including whether it is the product of the witness's own recollection. The occasions, if any, on which the witness failed to make an identification of the defendant or made an identification that was inconsistent with the identification at trial, and the occasions, if any, on which the trial was made, on the witness made an identification that was consistent with the identification at trial and the circumstances surrounding such identifications. Again, the state has the burden of proving every element of the crime charged, and this burden specifically includes the identity of the defendant as the person who committed the crime for which he is on trial. If, after considering the identification testimony in light of all the proof, you have a reasonable doubt that the defendant is the person who committed the crime, you must find the defendant not guilty. The court further charges you that if you are satisfied from the whole proof in the case, beyond a reasonable doubt, that the defendant, Brandon Isabelle, committed the crimes charged against him, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the crimes charged, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity from the proof, or you have a reasonable doubt as to whether he has been identified from the whole body of the proof in the case, then you must return a verdict of not guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged, and that it was committed before the finding and returning of the indictment in this case. Burden of proof venue. The burden is upon the state to prove by a preponderance of the evidence that the offense was committed in Shelby County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Shelby County, Tennessee, then you must return a verdict of not guilty. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless, from all the evidence in the case, you are convinced beyond a reasonable doubt that the defendant is guilty. You enter upon this investigation with the presumption that the defendant is not guilty of any crime, and this presumption stands as a witness for him unless it is rebutted and overturned by competent and credible proof. It is, therefore, incumbent upon the state, before you can convict the defendant, to establish to your satisfaction beyond a reasonable doubt that the crime charged in the indictment has been committed, that the same was committed within the county of Shelby and the state of Tennessee before the finding of this indictment, and that the defendant committed the crime in such manner that would make him guilty under the law here defined and explained to you. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Reasonable doubt is a real doubt of the defendant's guilt based upon reason and common sense after a careful and impartial consideration of all the evidence in the case. Proof beyond a reasonable doubt, therefore, is proof of such a convincing nature that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. It is not necessary that the defendant's guilt be proved beyond all possible doubt, because absolute certainty of guilt is not demanded by the law to convict of any criminal charge. but moral certainty is required. And this certainty is required as to every element of proof necessary to constitute the offense. Direct and circumstantial evidence. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of a fact and issue without inference or presumption. Direct evidence might consist of testimony of witnesses who saw or heard what happened firsthand. If witnesses testified about what they saw or heard, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact and issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. The law makes no distinction between the weight you may give to direct or circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Impeaching a witness. A witness may be impeached by proving that the witness has made some material statements at some point before the witness testified, which are different with his or her testimony on the witness stand. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, you may consider proof of any prior inconsistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Further, a witness may be impeached by a careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard the evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. Prior consistent statements are admissible to rehabilitate a witness or to respond to impeachment by a prior inconsistent statement. The prior consistent statements cannot be considered by the jury as substantive evidence and is to be used only in assessing the credibility of the witness. Any prior consistent statements can be used only as corroboration of the in-court testimony of the witness after impeachment by opposing counsel. You may consider proof of any prior consistent statements only for the purpose of determining whether the witness is telling the truth at trial. The contents of the prior consistent statement are not to be considered as proof in the trial. Expert witness. During the trial, you heard the expert testimony of Officer Brian Onan, who is described to us as an expert in the field of crime scene analysis. You heard the testimony of Special Agent Michael Garner, who is an expert in digital forensics. You heard the testimony of Sergeant Jason Bledsoe, who is an expert in digital forensics and extractions. You heard the testimony of Agent Stephen Walzak, who is an expert in forensic biology. You also heard the testimony of Jeffrey Neuschatz, who is an expert in confessions. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact and issue, the witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it is up to you to decide whether you believe the testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. If there are conflicts in the testimony of the different witnesses, you must reconcile those conflicts if you can, without hastily or rashly concluding that any witness has sworn falsely. For the law presumes that every witness has told the truth. It is your job to decide what the facts of this case are. When you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important you think the witness's testimony was. You do not have to accept or reject everything the witness said. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth, or did the witness seem to evade the question? Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Did the witness have a motive to testify truthfully or testify untruthfully? Have there been any promises, threats, suggestions, or other influences that affected how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently. Witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in the case. However, you may conclude that a witness deliberately lied about something that is important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part which you think is true and ignore the rest. The defendant not testifying. The defendant has not taken the stand to testify as a witness, and you shall place no significance on that fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand in his own behalf, and his election not to testify cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Members of the jury, the court charges you that if any of you have been taking notes in this case, your notes are for your individual use only. You shall not use your notes directly or indirectly, explicitly or implicitly, to persuade other jurors as to the accuracy of your notes. Your notes cannot be shown to others, compared or referred to in any way as authority. Your notes can only be used as an aid to your individual memory. No outside communications. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case outside the jury room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, or computer, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including, but not limited to, Instagram, Snapchat, Facebook, TikTok, YouTube, Google, or X, formerly referred to as Twitter. To communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. Unanimous verdict. Any verdict you reach in the jury room, whether guilty or not, must be unanimous. Your deliberations will be secret. You will never have to explain your verdict to anyone. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to discuss the case with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself only after a full consideration of the evidence with the other members of the jury. In the course of your deliberations, do not hesitate to re-examine your personal views and change your opinion if convinced it is erroneous. However, do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Having instructed you on the law applicable in this case, the attorneys may now present their closing statements. Pardon me, bench conference. All right, ladies and gentlemen, jury, it's my understanding that someone needs to take a break. I am not going to prevent you from doing that, but I want to direct your attention to page 8, the last full paragraph. There's mention the elements of first degree murder, second degree murder, strike through voluntary manslaughter. That's not what this is. That does not apply. Page 8, and then I need you to fast forward to page 21. We neglected to include Dr. Scott Collier as an expert in forensic pathology. If you may recall, that's when I stopped proceedings and explained to you that he performed autopsies and to prepare yourself. So that's Dr. Scott Collier, Collier, page 21, that was on the expert list. One of you needs to step away. It is now 1:20. Let's come back at 1:30 for closing arguments.
Ladies and gentlemen, the jury leaves the pen to pass to the chair.
You still can't discuss the case. I'll let you know when you can. Just leave your packets, leave your things, we'll take care of it. See you in 10 minutes. I'm sorry, I don't know where the deputy is. I'll handle that. Recess.
Court stands in recess.
Judge, jury, entered the courtroom.
Thank you. You may be seated. Does the state of Tennessee wish to make or give a closing argument?
Yes, Your Honor.
Go ahead, please.
Kennedy Hoyle should be 3 years old. She should be growing, learning, getting into things, driving her mom Danielle and her grandma April crazy. She'd be too big for this car seat, but she's forever frozen in time, not even 2 days old, along with her mother, Danielle. They're gone because of that man, Brandon Isabelle. He shot Danielle 5 times and left her in a ditch. He took baby Kennedy, drove her to the river, and tossed her in the cold, dark water. Ladies and gentlemen, you've heard all the proof that you're going to hear in this case. You've now heard the law given to you by the judge. You have 5 counts, and they're listed up on the screen for you. Now, you'll see in your jury instructions that there are lesser included offenses for each count. That is not a menu. You don't pick and choose. You have to start with the top charge. So in count 1, that'll be first-degree murder. Everyone has to agree that he's not guilty of first-degree murder before you move to a lesser count. Now, let's talk about count 1 and count 2. Talked about in voir dire elements, what the state has to prove beyond a reasonable doubt. You have count 1, which is premeditated first-degree murder as to the death of Danielle Hoyle. You also have count 2, which is premeditated first-degree murder as to the death of Kennedy Hoyle. The elements are the same. First, the state has to prove that Danielle and Kennedy were unlawfully killed, that the defendant acted intentionally, he intended to kill them, and he acted with premeditation. Now, in your jury instructions, intentionally is defined. It wasn't an accident. The defendant, he pointed that gun at Danielle and fired it at her, intending to kill her. He took Kennedy by the leg and threw her into the river. He intended to kill her. Now let's talk about premeditation. You have the full definition in your jury instructions. And you notice that it talks about reflection and judgment. But that there doesn't have to be a specific amount of time with regards to forming the intent of the purpose to kill. So, how did the state for counts 1 and 2 prove premeditation? The planning. Think about everything that you've heard over the course of several days. The defendant, he filed for divorce January 27th of 2022, mere days before he killed Danielle and Kennedy. What else? Kennedy is born January 31st of 2022. The defendant doesn't sign her birth certificate. Then we move to January 30th of 2022. And you heard Special Agent Garner tell you that they went through the defendant's phone. And what did they find? Web searches. 2 days out from the murder, and the defendant is searching Jared in the wedding ring section. And then he had some additional searches. Can all bullets be traced back to the exact gun that fired them? Can you tell what gun a bullet came from? Now let's move to February 1st of 2022. And you heard Special Agent Garner tell you that he was able to tell the defendant's movements throughout that day. And earlier that day, he's on Mart Road. And you heard Investigator Byers tell you that Mart Road is along Lakeview. And it's an easy turn to miss in the dark. And if you notice on the map, you take Lakeview and you miss Mart Road, next turn, Sedgwick and Levi. Dark, desolate, deserted. Now the defendant told us in his confession, and his GPS told us, he met Danielle at the MAPCO. And why? He told her he had baby clothes to give her. And what was found in the defendant's white Chevy Malibu? Baby clothes. And then we get to the scene. Levi and Sedgwick. He gets Danielle to meet him at that MAPCO. He convinces her to drive down Levi and Sedgwick. No lights, dark, quiet, raining. And he tells us in his statement that he had car trouble. Think about the scene at Levi and Sedgwick. Danielle's Chevy Cruze parked on the wrong side of the road. And what did the defendant tell us? She got in position to shine her headlights to help him out with his car trouble. And what did he do? He walked up to her Chevy Cruze. He opened the passenger door and he fired. 1, 2, 3, 4, 5 shots into that car, striking Danielle 5 times in the face and head. Premeditation. Now by 9:23, according to his GPS, he's moving on. He's leaving the area of Levi and Sedgwick. And who does he have with him? He has baby Kennedy. And while Kennedy's in the car, and he has left her mother dead in a ditch on the side of the road, he's covering his tracks. He's sending text messages to Danielle, knowing that she'll never answer. Now, he's been driving around. We're at about an hour. Kennedy's been in the car. And he stops off at home to get out of his murder outfit, those Adidas slides, that windbreaker-like jacket, the black and the greenish blue. Takes the time to hang that jacket in the closet. Comes back out, gets back in his car, and what does he do? He drives to Mud Island, all the way from Cordova, passing numerous exits, numerous houses, places. All that time, could have made a different choice. But he went, and he drove on Island Drive to get to Mud Island, to that boat ramp, and he took baby Kennedy by the leg and threw her into the Wolf River. Count 4, we're going a little bit out of order, is aggravated child neglect. And you can see the elements for aggravated child neglect, what the state has to prove beyond a reasonable doubt. That the defendant knowingly neglected Kennedy so as to adversely affect her health and welfare, that it resulted in serious bodily injury, and that Kennedy was 8 years of age or less. And there you have the definition of knowingly, as well as serious bodily injury, all defined in your jury instructions. What did the defendant do with Kennedy? He took her down to the boat ramp at Mud Island. In the dark, in the cold, in the rain, out of her car seat. And even if you believe that he didn't throw her in the river, he just left her by the river and she somehow managed to go into the river, he is still guilty of murder and perpetration of aggravated child neglect. Serious bodily injury or death. Adversely affect the health and welfare. He left her where she could fall into the river in the cold, in the dark, in the rain. And as you see, that goes hand in hand with count 3, and that's the murder and perpetration of aggravated child neglect. So in that count, the difference is the defendant didn't have to intend the killing. He had to intend the aggravated child neglect. Last count, especially aggravated kidnapping. You can see the elements. What do we know? The defendant, after shooting her mother, takes Kennedy, takes her from Levi and Sedgwick, drives around Cordova, goes to his parents' house, goes all the way down to the river, and kills her. The state has to prove identity. How do we know that the defendant Brandon Isabelle, is responsible for each and every one of these crimes. He told us. You listened to his interview with police. He told us. He told us exactly what he did. We have the GPS that Special Agent Garner went through methodically, telling us all the points of where he was located throughout that day and night. His phone, a silent witness to those murders. The text messages. And you'll have those text messages between the defendant and Artesia. They're going back and forth throughout the night. And why is that? Is it because they're in two different locations? They're not together? And there's the shell casings. The defendant, he told us, he shot Danielle with his 9mm. What do we find? 9mm shell casings in the passenger seat of Danielle's car, 2 in front of her car, and a loaded 9mm magazine in the defendant's white Chevy Malibu in the center console. And he told us what he did with Kennedy. That he took her to the boat ramp, took her by the leg, and threw her into the river. And what did he say in his statement? It didn't go as far as the gun. And what did officers find on that boat ramp? Kennedy's baby cap. Why'd he do it? What's the motive? You'll notice that is not an element that the state has to prove. But it's pretty clear, the motive here. And it's Artesia. The defendant wanted to be with Artesia. You heard her testimony. You've heard the text messages. She didn't want to have to deal with another child on top of her child, on top of the child the defendant already had, another mother in the mix. And so he came up with this plan. And he never wanted that baby. And you can see in that text message that he had sent to Danielle, what does he say? I can't be a father to that kid right now, Danielle. If you love me like you say you do, then let's end our mistake, Danielle. But Danielle wanted to be a mother to that little girl. That little girl wasn't a mistake. Now let's fast forward to January 30th of 2022. And you heard the text messages between Artesia and the defendant. And this is in the late night of January 30th. What we know is that Danielle's already at the hospital, and she's in labor, about to give birth to baby Kennedy. And what is the defendant texting? He's texting to wifey, Artesia, I love you. Baby, say it back. You doing this to me in a time like this? And what does Artesia respond? Tell her have a safe delivery. I'll talk to you when y'all get the results. Then we move in to those early morning hours, right around the time that Danielle is giving birth to Kennedy. And what is the defendant doing? He's still texting Artesia. He's still sending her messages over and over again. And what is Artesia's response? I'm gonna make this simple. If it's yours, build that bond. Get to know her as a woman because she loves you as well. I won't need no response. Silence will answer that for me. If it's not, we still need space to take this relationship slow. She's slipping away. His perfect woman is slipping away. And what does he do? While his baby has just been born, he's still sending text message novels to Artesia, professing his love. And they're still going back and forth. And he says to her, "This the worst I've acted over a female. Never wanted somebody so bad. You knew this day was coming. Why wait until now and all this love and time?" And then what do? That early morning, after Kennedy is born, they agree to meet up. And where does the defendant suggest? Where you want to meet at? Our river spot? Now we're at February 1st of 2022. 7:58, the defendant gets back to his home on Lathbury. Then he's gone again at 8:05, and he's dressed to kill. According to the GPS data, he's at the MAPCO at 8:32 to 8:51 p.m. And he says that in his statement to Sergeant Boyd and Sergeant Wimbush. He met Danielle at the MAPCO. And we found the baby clothes in the Malibu. Now we're moving on. Between 9:02 and 9:23, GPS has him at Levi and Sedgwick, and he admits to going there. And during this time, he and Artesia are still going back and forth. And you'll notice that from 9:04 to 9:22, he stops texting Artesia. All those blue messages, Artesia. Green messages, the defendant. And what is he doing in that gap in time, that 9:04 to 9:22? He's shooting Danielle 5 times in the head and the face and taking her sweet, precious baby and driving away. You see what's left behind. Danielle and those 9mm shell casings. And he drags her, and he tells us how he drags her out of that vehicle by the shirt. And look at her clothes. Look at how her jacket is pulled off her body. He killed Danielle. He left her in a ditch. He's driving around with Kennedy in his seat. He's texting with Artesia. And he takes the time to put in a food order. Cheeseburger, no onions, blue Kool-Aid. And what did Artesia tell us? That she stopped by Dixie Queen that night. And what did we find in her car? Looks a bit like a blue Kool-Aid. Now, we're back at 8702 Lackberry. Gets there at 10:24. You can see what he's wearing. You see those Adidas slides, those black socks. Goes inside, takes the time to hang up his jacket, changes his clothes, and he's gone again at 10:29, holding that blue bag. Baby Kennedy in his white Chevy Malibu. And what do they find in the trunk of that white Chevy Malibu? Those Adidas slides. And looks a bit like that blue bag he was carrying on the Ring camera footage. Where's he headed? Island Drive. And how do we know that that's the defendant? You heard Lieutenant Stanley testify that they had license plate reader hits on his tag going over the A.W. Willis Bridge. They were able to look back at camera footage from the Real-Time Crime Center, and they see that white Chevy Malibu driving up and down Island Drive. 10:59 to 11:20. And all that time, from leaving Levi and Sedgwick to 9:23, all the way to Island Drive, could have made a different choice. He had every opportunity to make a different choice. And we're at 10:54, right before he gets to Island Drive, and he's texting with Artesia. And what does he tell her? He tells her he just left the house. But we know he's down on Mud Island, getting rid of the last obstacle between him and Artesia. And at 11:13, right before he takes baby Kennedy and throws her into the river, he wants to know when Artesia's going to be around. 11:20 to 11:27. He's at the boat ramp, GPS. And he says that he threw the baby by the leg. And you'll have his interview. Notice that Sergeant Wimbush, he says he threw the baby by the arm, and it's the defendant that corrects him and says by the leg. Sergeant Boyd asks, how far into the water did you throw her? And his response, it wasn't far. It didn't go as far as the gun. And now, baby Kennedy is in the Wolf River. Danielle is in a muddy ditch on Levi and Sedgwick, being discovered by Officer Sutton. And what's the defendant doing? He's at Walgreens, buying stuffed animals, roses for Artesia. And writing a card professing his love and talking about raising Kennedy, who he knows he just threw in the Wolf River. And how do we know? Because we have video. We have GPS. And the defendant told us. Now, while we're at the Walgreens, what's going on? Texting Artesia. And what did she say? She said he shared his location, which wasn't normal for them. And she called him out on it in the text messages. And where did she say that location was? Walgreens. Is he trying to set up his alibi? Because he's also out there in the parking lot, and you can see it in the video, sits there for a while. And what's happening? Prior to arriving at Walgreens, he's sending text messages, once again, to Danielle. 11:39. Show me Kennedy. I'm gonna take her tomorrow. After not half an hour before throwing that baby into the Wolf River. 12:02. Give her a kiss for me. Just miss her. That's all. Love y'all. At 12:13, sends Artesia another text. Now he's on the way to Walmart. And what does he tell Artesia? I want to cuddle tonight. I ain't slept with you in a week. And then we arrive at Walmart. How do we know? GPS, video, and the defendant tells us. And he tells Sergeant Wimbush and Sergeant Boyd. He left the car seat at the Walmart. And Officer Blake, that's where he finds it. And what does he find? Finds the car seat. And then you heard from Officer Walker, a mitten. A matching set. The riverbank and Walmart. Then he goes to Stacy Road. And again, his GPS puts him there. Artesia puts him there. He's coordinating meeting up with her. And what is found in his Chevy Malibu? An empty gun holster, a 9mm magazine, and gloves with the cockle burr. And then by 1:07 a.m., he and Artesia are back at his house at Lathbury. Let's talk about the gun. There's been a lot of talk about Artesia had a .40 and a Smith & Wesson, and there was .40 caliber rounds found at Levi and Sedgwick. You saw how many rounds were found of various calibers at Sedgwick. You saw, when you zoom into that picture, that street sign that was covered in bullet holes. You heard Investigator Byers' video, and he said that jingling noise that you could hear were shell casings. But what shell casings were found in Danielle's passenger seat? 9mm. What shell casings were found just up from the car? 9mm. What magazine was found in the defendant's center console of his white Chevy Malibu? 9mm. And if you look closely, from in front of the Chevy Cruze, Hornady shell casing. In the passenger side of Danielle's vehicle, Hornady 9mm shell casing. And in the defendant's car, live rounds, Hornady 9mm. And what did the defendant tell us he did with the gun? He threw it in the river. What did we find? We didn't find the gun, but we found his gun box. And what was in that? More magazines for a 9mm. What gun did we find? We found Artisha's gun, a .40 Smith & Wesson. It wasn't missing. It was right there. And then you look at the scene at Levi and Sedgwick, and you can see, and those are placards 12 and 13. Those are those two shell casings from a 9mm in their Hornady brand. And what did the defendant tell us in his statement about what happened? After he shot Danielle, the car rolled. And you can see a pile of glass fairly close to those 9mm shell casings. And you can see Danielle's car in the distance, as if it rolled. Now, at one point, the defendant tells investigators, after he's had some time to reflect, oh, Danielle was an accident. Ladies and gentlemen, you heard Dr. Collier. Danielle was shot 5 times. In the head and in the face. This was not an accident. This was a premeditated execution. Then we have the DNA, the Adidas slide, seen on the defendant that night in that Ring camera video, found in the trunk of his white Chevy Malibu. And what did he tell officers about that during the interview? He said that Danielle's blood would be on the slides. He even specified which one, the left. And which one had Danielle's DNA, according to Agent Walzak? The left. And then he sits through that interview the entire time wearing those white socks with Danielle's blood on them. And you saw that he had a pair of black socks over them. And that blood had seeped through to those white socks. But Officer Carlisle found them. They went to the TBI to be tested, and once again, Danielle's blood on those socks that were on the defendant's feet. Ladies and gentlemen, the term victim is used a lot. But Danielle and Kennedy were more than that. Danielle was a mom. She was 27 years old. She was a girl mom. She had 9-year-old Jariah and her new baby, Kennedy. And then there was Kennedy, who will forever be, frozen in time, less than 2 days old, never getting the chance to grow up. Danielle's mistake was getting involved with that man. Danielle in Kennedy. They'll never do so many things. And it's because of what the defendant, Brandon Isabelle, did. Ladies and gentlemen, the state asks that you find the defendant guilty of every single charge of the indictment. Thank you.
Does the defense wish to give a closing argument?
Yes, Your Honor.
Go ahead, please.
Good afternoon. On a long journey. Not always pleasant. Counsel laid out a lot of facts. You did a very good job of it. But I want to ask you this, and I think this is where your concentration would be, particularly to count 1 and 2, which are the premeditated murder charges. And that is whether these acts were premeditated. That's the difference between first degree and second degree murder. To be premeditated, and that's one of the elements that the state has to prove beyond a reasonable doubt. To be premeditated, the court told you, and it's a short instruction, so I'm going to repeat it here. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act, before the shooting, before the baby, before throwing the baby. It's not necessary that the purpose to kill pre-exist in the mind of the accused for any different definite period of time. This is where I want you to look. The mental state is on page 4 of the jury instruction. The mental state of the accused at the time he decided to kill. About midway of the page. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused, whether Brandon, was sufficiently free of excitement and passion. So as to be capable of premeditation, because that requires reflection, cool thinking, reflection and judgment. So the state has to show that he's sufficiently free of excitement and passion. Now, I was reading this over. I also looked at the next sentence, and it says, if the design to kill was formed with premeditation, it doesn't matter if they were acting in a state of passion when they acted. Well, I ask you this. Is there any evidence anywhere that you've heard throughout this entire proceeding that Brandon was thinking about taking the lives of Danielle or that baby? Or started hers. There's not. There's no plan that he was going to kill that child or Danielle. So why? What in the world? What drove him? That's where we moved our teacher. Can there be any doubt from what we've heard and even from the state's argument that he was head over heels in love with her? That's passion. Head over heels in love with her. And what would she do? How would she, I mean, let's look at this situation. What we've got is Brandon and Artisha over here, and they're a hot couple. And you've got Danielle and the baby over here. Now, Artisha does not want him around Danielle. She says she's a nobody. It's the baby. And you told me it's not yours. She wants him for herself. And she even says in her statements that she's a narcissist. She wants him to herself. And I respectfully say that to me, and I hope to you, if she manipulated him, she tortured him, his love. And I'll show you why I say that. And she pushed him. She drove him. So she wanted more than anything in the world, rightly or wrongly. Artisha. He loved her. You can't reason with love. You just can't. Go through a few of these, and it's a big stack. It is full of what I'm telling you. I pulled out some of the larger pieces. Okay? It is full. Please read through it and consider what I'm telling you in this class. On the 30th, at almost midnight, he had texted her, Brandon had texted her, I love you. And she sent an emoji with a heart. And it's got love. And he says, you text there, but you can't say you love me back? What would you do? What would she do here? Let's look at the time we're at. With the day before the baby's delivered. With the day before. So their relationship is strained. And he's going to the hospital. And she just says when he says, you can't say you love me back. She just says, get there safe to the hospital. Get there safely. Wow. Good night. Tugging. What? He says, You're doing this to me in a time like this. Coming to have a safe delivery. I'll talk to you when y'all get the results. What results is he talking about? The DNA. The DNA results. Because Brandon's told her all this time, copy out here. She's wanting to know what the results are going to be. I'll talk to you when you get the results. But she goes further. She says, let me know the results. My stomach hurts, so this relationship is at stake. Now to Brandon, that's shaking his world, because he is in love with Artesia. He's smitten with Artesia. And she knows it. And so he texts her and says, look, do you want this or not? You want to be with me or no? And her response is no or no. I think she's gonna be in the way. To me, I submit to you, that's an important statement there on page 11. I think she's fixing to be in the way. What's she getting at? Not saying it. What's she getting at? Then she goes further. I'm going to make this simple. If it's yours, build that bond. Get to know her as a woman, because she loves you as well. I won't need no response. Silence will answer that for me. We still need this. We still need space to take this relationship slow. And talking about the birth certificate, sign if it's yours. If it's yours, sign. Don't call me. Don't call me if it's yours. That's what she's told me. Then we get to that long statement of Brandon's where he's just basically pouring out himself to her. And this is on January 31st at 3:48. That's when the baby's delivered. I really want to say this to your effing face. No emojis needed this time. Look, I effing love you, Artesia Lachey Isabelle. Call her by his last name. Of course, he likes her as wifey. I love you and only you. You meant the world to me, baby. I want to say this to your face. No tears needed, because I want you to understand where this is coming from, my heart. This makes me look at women different. When I got with you and found out about this situation, I know it makes you look dumb to the world for being with a dude with a baby on the way. But I heard the same thing from people when you were pregnant. People were saying it was my baby. How do I feel? Why am I with someone else's baby mama having sex, etc.? But I tuned it out because I knew what I wanted eventually. It may have took me a long time to make the move, but that's only because I know how my heart is, as you have clearly seen twice. When I love hard, and it breaks me down to let somebody that's my world leave me. I visioned it long before us. I visioned it being us 5 together. And I respectfully submit to you what he's talking about is him and Artesia. Artesia's child, Aaliyah. Kingston, his one child, and the baby. Like I've talked, 5 of us together, and I've talked to Denisha about it. Kingston being the oldest and the brother to protect his 2 little sisters. Me and Kingston being the men of the house to protect our 3 queens. Me and Kingston will forever have y'all. I will continue to teach him to be a gentleman, to hold doors for women, what side of the sidewalk to walk on, etc. Us 5, nothing can defeat us. I'll have either full custody of Kingston or joint, so there won't be any he can't come around. She'll have to deal with it, but that's how. Fighting so little. She'll have to deal with it. How I have. But that's nothing I have to explain to her. She might have my son because of court rights. And Danielle, time will tell. This was on the 31st. Time will tell, but if you're willing to talk to her like you say you are, then maybe that'll be a good start to something special for us and for the baby. I would say talk to Danielle. She might be reasonable. Maria, I wouldn't advise anybody to talk to her. And as I sat there, I thought about all this. I would want somebody by my side to be a great stepmom and even a greater mother. I love when Kingston smiles at you and plays with you. It warms my heart. My dad even asked me that before. You like that, don't you? I said yes. I hope you can look at the baby like that. I want to be able to call you later down the line and say, while he's at work, check on you, and you say, oh no, babe, me and the girls are just going shopping, or me and the kids just ran to Walmart or something. I want to see Aaliyah having a stepsister and eventually play with and talk with and hang with us in later years. All of these things are what I want. And why not want them with the love of my life? You are where my heart is. You are home. You don't have to respond. I know your mind is everywhere, baby. I understand. Just continue to read this over and know this is real and this. I'll give you your time again. I love you. Good night. Whether he should have been or not, Brandon Isabelle was head over heels in love with Artesia. And what did Artesia say that pouring out of his heart? He said, just take care of your children, Brandon. Because what they're talking about is breaking this relationship up, because she doesn't know if she wants to be in this situation. She's got a baby with Surrey and Kingston. He's got a baby with Danielle, and he's in love with her. And she doesn't know. She's in love with him. That's her. And she didn't know she was to step into that situation because everybody who's heard or knows that it can be a situation at times. She doesn't know she wants to go there. So she says, just take care of your children, Brandon. She's not responding to the profession of love that he's poured out. She says, don't want to look any dumber. I got my answer. I don't hate you, but that's the man you are. And thank you for the journey, and I pray for this. And it gets worse and worse for a reason. Love isn't my best favor. I just hope everything works out for y'all. So she's playing now. When you go to Danielle, everything will work out for y'all. It'll be okay, knowing that he is in love with her. P.S. She's a good woman, and she can help you through a lot. Just give her a chance. For me, this is my last message. He said, well, what do you mean, the man I am? What's that? You knew all the time. Sure, baby? But can you please leave me alone? Please leave me alone. And then she keeps writing. How many pounds? What's her full name? Answer my question. What's her full name? She says, if it's yours, I don't want to talk to you anymore. You want to be with her, Danielle. And he's saying, no, I don't. I want to be with you. I don't want to be with her. And she goes with the kind of reverse psychology again. I'm trying to get y'all to be a family. Y'all work it out. I regret this. You don't have to come back and get nothing. Delete my mom's number, just everything. Pictures, burn it. All. I don't want to remember none of this. Why are you doing this to me at a time like this? And now she turns to, I'm hurt. I'm very hurt. I just want to cry and be held. And then she comes back. She says, I love you, babe. I love you, babe. He said, I love you too. And then we go right back. I'm afraid we're not fixing to be the same. Why? Why are they not going to be the same? It doesn't take a lot of deep thought to get there. baby and Danielle. Is Brandon saying that? He wants her to learn to be a good stepmom and a good mother. How are we gonna make it work? I'm trying my best, this is her, wife. I'm trying my best in this situation, talking to her like I'm supposed to feel about my so-called man in the hospital hours. I hate this for me. But this ain't doing nothing but building a wall. You expect me to be loving in a situation like this, I'm all over the place. Danielle, Patricia. This is where you have hospital. And she's about to work on the 31st. And she tells him, I've been trying to prepare, but I wasn't fully prepared for this situation. I'm sorry. I'm selfish. And she tells him about the paternity tests. I want those paternity tests. We'll talk after the paternity test. The DNA, I'll go by and bring it to you. The little Walgreens where she went down and bought the DNA test. You swab her, you swab the baby, and get it back to me. I just don't want you getting too close to it. And she's not yours. And again, what's her last name? What's her last name? After 4:30 in the morning, I feel you will leave me for them. Our relationship is at stake, even on mine. And she starts, you don't intend to leave her, do you? You don't intend to leave her. I'd rather you get away from someone as worse as you. I'm a narcissist. Somebody that loves themselves, looks after themselves. This is all for, I hope, I beg you to. I don't want to do this anymore. Goodbye. You've claimed all this time you want me and miss me, and then you push me back like this. I've never been hurt in my life like this. We don't need to even be or even deal with each other. Thanks. Be good. Give me 1 second, I'll go do the next. You stay at the hospital, Brandon, or you go home, but you can't come here. We just can't be together. I'm sorry. It's like you making this situation heavy on me. My heart never felt like this, and my mind has never throbbed like this. We just need to leave each other alone. And I love you. We just need to leave each other alone. I want you, but we just need to leave each other alone. Let's play. Get away. She said, I'd rather be alone. That's how I've been lately. And on, and on, and on. So, I ask you say beyond a reasonable doubt that Brandon was not driven by passion? Would you mind resting for me?
Your Honor, reverse.
Pardon me.
Can your mind rest easily as to the state establishing provocation beyond a reasonable doubt? Our teachers, get away from Danielle. Prove the baby isn't here. Get a test. Don't come back to me till it's done. It's yours, I'm not talking to you anymore. Carefully examine what your jury instructions tell you. Carefully examine the mental state of Brandon Isabelle. Regarding count 5, which is especially aggravated kidnapping, under the state's theory, Brandon took the child after shooting Danielle, took it with him. He kidnapped her at that point. You get to say. here's what the jury instructions are going to say. Unless you find beyond a reasonable, page 13. Unless you find beyond a reasonable doubt that the alleged victim's removal or confinement exceeded that which was necessary to accomplish a first-degree murder and aggravated child neglect, and was not simply incidental to it, a part of it, then you must find the defendant not guilty of the statute of aggravated robbery. I respectfully submit when you remove premeditation, that leaves you with second degree. I think, and submit to you, that's what the state's proof has shown you. And to reach a verdict, you have to be unanimous. That's true. But you don't have to reach a verdict if you can't agree. You only reach a verdict if you agree. If you don't agree, you see if you try to work it out. If you can't, you don't agree. You ain't got a verdict. To have a verdict and return a verdict, it must be a unanimous 12 people agreeing. I just wanted to be sure everyone understood that. Always talk to your fellow jurors. Keep an open mind, but do not give up your own belief, your own conviction, simply to reach a verdict or because other jurors think differently. Be strong. Thank you.
Does the state wish to give a rebuttal argument at this time?
Yes, Your Honor.
Go ahead, please.
Thank you, Judge. I got to clear something up real quick, because when you look at the premeditation jury instruction, passion in there does not mean that because you're in love with someone and they don't love you back, you can go start killing people. That's not what that means. That is a passion that's born of provocation. Somebody does something real bad to you. You know, somebody beating on your kid and you just lose it and you kill them. You come home and your spouse is cheating on you, so you kill somebody because of that. That is the passion, and it's born of provocation. Not oh, I love Artesia so much. I think I'm going to go kill a bunch of people that are in the way. That's not what it contemplates. Anger, rage, sudden excitement, that sort of thing is what that contemplates. And I want to talk about, I thought that he didn't mention Neuschatz at all, and I guess it makes sense because that guy didn't even look at the facts of the case. He didn't mention the idea of a false confession. He forgot about that because obviously it's not a false confession. But I want to take you back just a little bit to go to this premeditation idea, right? Where did the defendant start his day? What did he say in his statement? He was at Regional 1. We remember that. He went to Regional 1. Why was he at Regional 1? What was he doing at Regional 1? That's where Kennedy was being born. Why is he there? This guy hasn't been paying any attention to Danielle for months. We know, based on the prior text, that he doesn't even want the baby. So why? Why is Brandon Isabelle at Regional 1? To try to take down Danielle's defenses. He doesn't care about that baby. He doesn't want that baby. But he's planning on killing that baby. That's what he's doing up there. He didn't go to Regional 1 because he loves Kennedy. Because if he loves Kennedy, he wouldn't have thrown Kennedy in the river. He didn't go up to Regional 1 because he loves Danielle. Because if he loved Danielle, he wouldn't have shot her in the head 5 times. That's planning, ladies and gentlemen. And again, forget about that definition he was giving you of passion, because that's not the definition for passion. That is planning. It's premeditation. What does he do the rest of the day? He goes to the surgery center for his kids, and he goes home to Lathbury. Now think about this. He goes home to Lathbury. It's just later on that day. And we see him going into Lathbury. It's about 7:58. What's he wearing? He's wearing those slides. He comes right back out of Lathbury, And he has done what? He's done what? He has lured Danielle to the MAPCO. His heart isn't just filled with love for Artesia. He wants to kill Danielle. That's why he lures her to the MAPCO. Long time goes by. He drives all the way to MAPCO, and we have his GPS taking him all the way to MAPCO. What else do we have? We have text messages between him and Artesia. And what's Artesia saying? Who can blame Artesia for not wanting to be with a guy that's having a baby with another woman? That's kind of normal, right? But is she texting him going, yeah, kill, kill, kill. You're not going to have me unless you wipe out these people. No, she's just texting normal things. They're planning on going out and have dinner in those texts. She went and bought him food from Dixie Queen. There's none of that kind of madness right there. They're just having normal conversations. It's up, it's down, it's in. You know, they're on the rocks. Seems like maybe a toxic relationship, but she's not inspiring him or encouraging him to kill anybody. I mean, we know he's on the scene, but he gets her, and think about his statement too, and his statement is corroborated by all the proof, but he lures her to the scene at Levi and Sedgwick, right? What's going on there? It's a dark scene. We know he already cased the place because he went to Mart Road earlier in the day. That day, he went to Mart Road. Mart Road is just like Levi and Sedgwick, it's right next to Levi and Sedgwick. And he lures her out there, says his car's messing up. His car's not messing up. He gets her out there, and he's got his gun with him. He has his 9mm gun with him. Why? Why in the world would he lure Danielle out and bring his gun with him? That's weird. Seems like maybe he had a plan to kill Danielle. And he gets her out there, and he shoots her 5 times. 5 times in the head. No, we can just skip that one. He shoots her 5 times in the head. Car rolls back. It's pretty obvious he's the one that shot her, right? They didn't even argue against that. 9mm Hanaday rounds laying on the ground, pile of glass, car rolls back, just like he said. Remember, he's the first one that said that. He's the first one that said he used 9mm. He's the first one that said he shot her, and the car rolls back 20, 30 feet. What does he say he does?
Patrick Byrne, Organized Crime Division.
What does he say he does? He pulls Danielle out of the car, pulls her body out. What kind of passion is that?
Turn it off.
He's just trying to get rid of the body, right? He grabs Kennedy and does what? Puts her in his car. Is that okay? What's that? That's kidnapping. He had no right to take Kennedy and put her in his car after he killed the mother. It's not passion, that's planning. That's planning. He brought the bullets with him, he brought the gun with him, and he aimed it right at her head, and he fired it 5 times. That's premeditation. It's premeditation. Now, the inspiration is Artesia. He's worried about losing Artesia. That's why he killed her, but it's not because of some passion. He planned it. He planned it for days. What is it? What happened? How about the Google search, right? He's searching on Google about whether or not shell casings can be traced back to a gun. Was it a passionate Google search? No. He sat there and he typed in the words, and he searched, and he found out, probably, yeah, they can trace guns back to bullets. And what does he do with the gun? He throws the gun away. Passion. No, that's planning. That's planning to get away with the murder. But what does he do with the baby? What does he do with baby Kennedy? He puts her in her car and he drives all the way back to Cordova. What is that? He's planning on how to get rid of, he's trying to figure out how to get rid of baby Kennedy. Trying to figure out, how can I get rid of this baby? What can I do with this baby? He said in his statement, I got to kill that baby because I didn't want to be a single parent. Yeah, the baby's in the way. Baby Kennedy's in the way. But he knew what he was going to do because he drove all the way out there, 30-minute drive all the way out to Lathbury. And what's he wearing when he walks in the door at Lathbury at about 10:24 p.m.? He's wearing the murder slides. The slides with Danielle's blood on them. He's wearing them when he walks in. He's not wearing them when he walks out. Because he put them in a bag, and he put his murder clothes in a bag, and he put them in the trunk of his car so as to hide it, so nobody could find it. That's planning. Maybe not the best planning, but it's definitely planning. He goes all the way down. All the way down to Mud Island. Is that a passionate killing, or is that a long, long bit of planning on how he's going to get rid of that baby? Drives all the way down to Mud Island. Now he's had the baby for, oh, I don't know, an hour or so? Is he still killing the baby because of the undying love that he has for Artisha? Just some passion? You know, no, he's planning to kill the baby. He's planning. He's trying to figure out, what am I going to do with this baby? Because we see his car go over A.W. Willis Bridge, photograph of his tag. We see the white Chevy Malibu driving up and down Island Drive, looking, searching. Where am I going to dump the baby? Where am I going to get rid of this baby? How am I going to kill this baby? And again, why did he throw the gun in the river? That's planning. He told them that those Adidas slides that he had on had her blood on it, had Danielle's blood on them. What did they have on them? Danielle's blood. That's corroboration for his statement. What else did he have on him that whole time? The whole time during that interview. Remember what he had on his feet. He had those socks on his feet. Hours into the interview, after they brought him down to the river and he's pointing out where he left the baby, he had the socks on with what? With Danielle's blood on them. He had the black socks pulled up over him. He said he threw baby Kennedy in the river. And we found her hat right down there by the river. Some hour and a half after he kidnapped her from the scene where he killed her mother. What does he do after he kills her? He runs to Walgreens. Or he drives to Walgreens. And we know he drives to Walgreens because we have his GPS, and he gets at Walgreens and we see the video of his car circling around Walgreens, and he backs his car in and he goes inside Walgreens and he buys some things. He buys rose for Artisha. And he buys a card. Remember what the card said? What did the card say? Dear Artisha, dear Cookie, whatever, we're going to raise Kennedy together. We're going to raise the baby I just threw in the river together. Love, Brandon. What else is he doing though? At 12:06, around midnight, when he gets to Walgreens. And remember 12:06. Remember what's happening at 12:06? 12:06 was the very time, the very minute that Danielle Foyle was declared dead. She's been sitting in a ditch all this time with her blood soaking in with the water running down the ditch. And a paramedic has finally declared her dead at 12:06. And at that very minute, what is this guy doing? He's sitting in his car at the Walgreens parking lot. What's he doing in the car? Writing a little love note to Cookie. What else is he doing in the car? He's writing texts, sending texts to who? To Danielle. Kiss the baby for me. Well, I guess you're asleep. That's diabolical. That is diabolical planning is what that is. Absolutely. Setting up his alibi. Sending text messages to the woman who he just fired 5 shots into her head, talking about the baby that he just threw in the river. But then what does he do? Got to get rid of some more evidence, right? Jumps in his car. GPS's his way right on down to Walmart. We see him on the video. The familiar Chevy, the familiar car he's driving. Chevy Malibu. We see a figure get out and drop off what turns out to be the car seat. The car seat. The last known refuge. The last little piece of comfort that baby Kennedy had before he pulled her out of it. So yeah, Yeah, his motive was to kill these people, to kill Kennedy and to kill Danielle so he could clear the deck, so he could be with Artesia. But he's not under any kind of passion. He's not under any kind of provocation. That's just his plan. That's just what he needs to do, what he feels like he needs to do. I want y'all to think about Kennedy, okay? Kennedy, sitting down there by the river. Kennedy, 45 hours old. And he puts her down there by the river. And she can't walk, right? She's not in that when he puts her down in the river. She can't walk. She can't swim. She can't hold her head up. She can't make a phone call. She's just left down there by the river. What she needed at that moment was what? She needed a blanket. She needed her car seat. She needed April. She needed the beautiful family that he just lured her away from, that had just showered that little baby with love for the hour that they had her. That's what she needed. That's what Kennedy needed. What did she get? She got lured away by this guy who was planning to kill her. She got lured away by him. What else did she get? She got dragged down to Levi and Sedgwick, and you've seen Levi and Sedgwick. That ain't no place for a baby. What else did she get? She had to sit in that car a foot or two away from 5 gunshots. 5 loud gunshots that must have almost burst her little eardrum. She's only 45 hours old, and she's already subject to 5 gunshots 2 feet from her head. Most of us live our whole lives without having experienced that. But that's not all she got. She got to watch those bullets enter the head and neck of her mother that had just given birth to her. What else did she get? She got to watch this guy drag her mother out of the car and throw her on the side of the road like a piece of garbage. But that's not all. What else did she get?
John, do me a favor.
Pardon me. I'll be right with you. Mr. Christensen, I hate to interrupt your closing any more than it already has been.
Thank you, Judge.
But I've been asked to take a break by one of the jurors. So I'm happy to bring them back so that you can finish. But I don't know what their needs are. I don't know if it's a bio break. I don't know if it's a medication break. But I have to give them a break.
Oh, yes, ma'am. No, I don't want to.
But I don't want to take it away from you. So do you mind if we take a 10-minute break for the jury?
Not at all.
Ladies and gentlemen, you're not to discuss anything. The deliberations have not begun, and if there are any statements that have been made that are inflammatory that you do not believe the evidence supports, you shall give it no weight.
Excused.
See you in a bit.
Step.
Then discuss amongst yourselves when you want to eat. All right, welcome back. It is now 3:14. We're a little early. Thank you for communicating your needs. While it's not customary that we interrupt councils, I can't have you there needing a bio break or medication or food. So if you have additional wants and needs, let us know. Don't hesitate. We are here to take care of you. Go ahead, please.
Thank you, Judge. All right, ladies and gentlemen, now I have to start over. Just kidding. All right, well, I was talking about baby Kennedy, okay? And I was talking about the needs of a 45-hour-old baby, right? What does a 45-hour-old baby need? Baby needs comfort, right? Baby needs to be held. The baby needs to be kept warm. The baby needs a mother. The baby needs a father. The baby needs a real father. But what did baby Kennedy get? What did she get? She got lured away from her family, from the family that had just given her all that unconditional love that a little baby needs, showering her with all the things that a baby needs. For 1 hour. She got lured away from that, and she got brought down to Levi and Sedgwick, where she was in the car when 5 shots rang out. That's what she got. She was in the car when her mother got shot 5 times in the head and neck. She was in the car when her mother got dragged out of the car and dumped on the side of the road like a piece of garbage. Then she got kidnapped. She got taken out of that car and put in the white Chevy with him. And she gets driven all the way back out to Lathbury, and she gets driven all the way back down to Mud Island. A trip with this kidnapper that lasted longer than the time she was able to spend with her grandma, longer than the time she was able to spend with her family. And then what does he do? He gets down to the river. She was in her car seat, but he takes her out of her car seat. Do we think during all that trip that the guy that wants to kill her is comforting her in any way? Do we think he gave her a bottle? Do we think he changed her diaper? Do we think he hugged her? Do we think he did anything to comfort that little baby? He gets out there, and what's the first thing he does? He takes her out of her seat. He takes her out of her seat. He takes her out of the last vestige of comfort that she had. It's February. It's 11:20 at night. It's cold. It's raining. It's raining, that cold steel rain that you get in February that we've all ducked and run from. And he walks down that old, decrepit boat ramp. There's rocks. There's mud. There's trash. There's old dead bushes and grass. And he walks down there, and he gets her right to the water's edge. And this hat really should tell you, this is her hat. Look how tiny this thing is. And he walks out there, and he gets to the water's edge. The Wolf River. The Wolf River, right where it goes into the Mississippi River. It's a dangerous river. It's cold. It's 38 to 42 degrees cold. It's so cold that your body will go immediately into hypothermia if you don't get out super quick, but the little baby's not going to get out of it super quick. There's dangerous currents. There's unpredictable currents. There are catfish and creatures in that river. It's dark. It's full of mud and silt and rocks. Premeditation. Because what does he do? Grabs her by her feet and throws her in. And her hat just falls right there by the edge. And as she's circling the water, going into that dark, cold void, what does he do? He just walks away. He just walks away. Let's think about intent and premeditation with respect to that act. Okay? What did he think? What do we think he intended when he took her out of her little car seat? What do we think he intended when he drove her all the way down to Mud Island? What do we think he intended when he drove her right to the boat dock? What do we think this guy intended when he took her out of that car seat? What do we think he intended when he took her away from her blanket on that frigid February night? What do we think he intended when he took her away from her mittens on that frigid February night? What did he intend? He intended to kill her. That, ladies and gentlemen, is premeditation, and that is also the most egregious kind of aggravated child neglect that one can imagine. Putting a little baby like that in that situation. It's cold, it's callous, it's premeditated murder. Now April Campbell deserves justice for what happened to her family. She lost her 27-year-old daughter. She lost her 27-year-old daughter. And we kind of lose sight of that because we talk a lot about baby Kennedy, but 27 years old. Murdered. 27 years old, 2 days after giving birth. Happy as she could be. She didn't need him. She didn't care about him. She would have been just fine without him. But he killed her when she was 27 years old. What else did April lose? What else did her family lose? She lost her little granddaughter. April Campbell got to spend an hour, 1 hour with her granddaughter. She deserves justice, ladies and gentlemen. Danielle Hoyle, Kennedy Hoyle, they were people. We talk about all these legal terms and we're having all our arguments and we have all the autopsy photos and all the jargon and all the mumbo jumbo, but don't lose sight of the fact. They were people and they mattered. You know, I've been doing this a long time. And when you have a case like this, it gets in your soul. It really does set with you. It leaves a mark on you, and it never goes away. It never does. And we've had this case for a long time, and when I get to this point, it's difficult. It's difficult to give it up. It really is. But now's the time. Now's the time for us to give the case to you. For us to give the case to you to make a decision, and we know that you'll do the right thing. We know that you'll do the right thing with the case. I'm going to ask you to bring back the verdict that common sense demands, the verdict that common sense dictates, the verdict that all the evidence dictates, the verdict that justice absolutely demands. Brandon Isabelle, he's guilty of the premeditated murder of Danielle Hoyle. He is guilty of the premeditated murder of Kennedy Hoyle. He's guilty of the aggravated child neglect of Kennedy Hoyle, and he's guilty of the murder and the perpetration of the aggravated child neglect of Kennedy Hoyle. And he's also guilty of the especially aggravated kidnapping of of Kennedy Hoyle. And we really do appreciate your time, ladies and gentlemen. It's been a long, long road, and we appreciate your time.
When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict, you will return with your decision to this courtroom, and your foreperson will deliver the appropriate verdict form to the court. The defendant has been charged with several crimes. The crime charged in each count of the indictment is a separate and distinct offense. The number of charges is no evidence of guilt, and this should not influence your decision in any way. It is your duty to consider the evidence that relates to each charge and to return a separate verdict for each count of the indictment. Your decision on one charge, whether it is guilty or not guilty, should not influence your decision on any of the other charges. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charge must be stated in your verdict. If you find the defendant guilty on all counts from the evidence beyond a reasonable doubt, you should convict on all. If you find from the evidence beyond a reasonable doubt one or more counts guilty and have a reasonable doubt as to the guilt
of the other counts or counts, you should convict on the counts you are satisfied by a reasonable doubt as to the guilt of, and acquit on the others. If you have a reasonable doubt as to the guilt on all, you should acquit on all. In deciding the guilt or innocence of the defendant, you shall first consider the offense charged in count 1 of the indictment. If you unanimously find the defendant guilty of first-degree murder, premeditated killing, beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of first-degree murder, premeditated killing, or if you unanimously have a reasonable doubt of the defendant's guilt of that offense, your verdict must be not guilty of first-degree murder, premeditated killing. And you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within count 1 of the indictment. You shall not proceed to consider any lesser included offenses unless you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count 1 of the indictment, you shall return a verdict of not guilty and proceed to the next count. Verdict form. The charged offense in the indictment is first-degree murder, premeditated killing. The lesser included offenses within the indictment are as follows: second-degree murder, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder, premeditated killing as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of first-degree murder, premeditated killing as charged in the indictment. If you unanimously find the defendant not guilty of first-degree murder, premeditated killing as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not of the lesser included offenses in order of their consideration as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of blank as included in the indictment. Insert in said blank space the lesser included offense. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be: we, the jury, find the defendant not guilty of count 1. You will write your verdict as to the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 1 of the indictment, you will next inquire as to your verdict in count 2. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 2 of the indictment is first-degree murder, premeditated killing. The lesser included offenses within the indictment are as follows: second-degree murder, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder, premeditated killing as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of first-degree murder, premeditated killing as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of first-degree murder, premeditated killing as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense. And then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offenses as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of blank as included in count 2 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 2. You will write your verdict as to count 2 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 2 of the indictment, you will next inquire as to your verdict in count 3 of the indictment. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 3 of the indictment is first-degree murder, killing, and perpetration of aggravated child neglect. The lesser included offenses within this indictment are as follows: second-degree murder, reckless homicide, criminally negligent homicide. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of first-degree murder, killing, and perpetration of aggravated child neglect, as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of first-degree murder, killing, and perpetration of aggravated child neglect, as charged in count 3 of the indictment. If you unanimously find the defendant not guilty of first-degree murder, killing, and perpetration of aggravated child neglect, as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offense as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offenses in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of blank as included in count 3 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 3. You will write your verdict as count 3 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. After you reach a verdict in count 3 of the indictment, you will next inquire as to your verdict in count 4 of the indictment. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 4 of the indictment is aggravated child neglect. The lesser included offense within the indictment is as follows: child neglect. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of aggravated child neglect, as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of aggravated child neglect, as charged in count 4 of the indictment. If you unanimously find the defendant not guilty of aggravated child neglect as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense, and then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offense as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be, we, the jury, find the defendant guilty of child neglect as included in count 4 of the indictment. If upon all the proof you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment, under the law defined and explained to you, it is your duty to acquit him, and your verdict should be, we, the jury, find the defendant not guilty of count 4. You will write your verdict as count 4 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. If, after you reach a verdict in count 4 of the indictment, you will next inquire as to your verdict in count 5 of the indictment. You will use the same rules in this count as you were instructed to use in the previous count. The charged offense in count 5 of the indictment is especially aggravated kidnapping. The lesser included offenses within the indictment are as follows: aggravated kidnapping, false imprisonment. When you consider your verdict in the indictment, you will first inquire whether the defendant is guilty of especially aggravated kidnapping as charged in the indictment. If you unanimously find the defendant guilty of this offense beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of especially aggravated kidnapping as charged in count 5 of the indictment. If you unanimously find the defendant not guilty of especially aggravated kidnapping as charged in the indictment, or if you unanimously have a reasonable doubt of his guilt of this offense, your verdict must be not guilty as to this offense. And then you shall proceed to determine whether the defendant is guilty or not guilty of the lesser included offense as set out in these instructions. If you unanimously find the defendant guilty of a lesser included offense in the indictment beyond a reasonable doubt, your verdict should be: we, the jury, find the defendant guilty of blank as included in count 5 of the indictment. If you find the defendant guilty, you can convict him of only one of the above named offenses charged and included in the indictment. If upon all the proof, you unanimously have a reasonable doubt of the defendant's guilt of the offenses charged and included in the indictment under the law to find and explain to you, it is your duty to acquit him, and your verdict should be: we, the jury, find the defendant not guilty of count 5. You will write your verdict as count 5 of the indictment on the outside of the jacket and sign one of your names to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and report to the court such verdict as truth dictates and justice demands. You may now begin your deliberations. However, 3 of you will not be joining your colleagues. We will be choosing alternates to remain seated as the jury goes back to the room to deliberate.
Number 12.
Hilliard. It is now 3:37. I suspect that Deputy Moore will have a conversation about the order of events. Those of you who are going to the deliberation jury room, she will speak with you on your way there. The 3 of you remaining, please remain seated, and we will follow the instructions of the Shelby County Sheriff's Office about our next steps. Thank you all.
Troops excused, bring your notebook with you, except for 3 that's remaining.
You may be seated. The court's going to be in recess.
Court stands in recess.